Senator Lee, I'd like to address the quid pro quo allegation head on by entering into the record the official court transcript from Mayor Adams' case. This isn't speculation or secondhand reporting. These are sworn statements under oath in federal court. As you can read in the transcript, Mayor Adams, under oath, flatly denied any improper arrangement. In his own words, quote, "There was no deal, no quid pro quo, and I did nothing," end of quote. Senator Lee.
Thank you, Mr. Chairman. Thank you, Mr. Bove, for being here and for your willingness to serve in the capacity as a judge on the Third Circuit. As a federal appellate court judge, you'll be called upon to interpret federal law under countless circumstances. When you're interpreting a provision of the Constitution or of the U.S. Code, where do you start? What does that process entail? Tell me to what extent you would consider things like committee reports and the subjective musings of individual senators and representatives as they're debating federal law before it's enacted.
So if I could start by differentiating between some comments about judicial philosophy, which I think go to the heart of your question, Senator, from the practical reality that if I'm confirmed in any case, I would consider and evaluate the arguments of the parties as they're presented. That said, with respect to my philosophy, whether it's constitutional interpretation or statutory interpretation, I would begin with the text of the operative provision that drives the party's dispute. I don't think that in most instances, committee reports or legislative history has a lot to say about what the meaning of that text really is for purposes of the dispute. And that is because I think in the main, the legislative history has not gone through the process of bicameralism and presentment to become law. And a judge's job, in my view, is to declare what the law is, not what it should be or ought to be or someone on a committee thought it sounded like. It is to focus on the operative words and interpret them as they're written.
What do you do in circumstances where it may appear that one or more lawmakers had a subjective intent surrounding a particular word or phrase that differed from that of the original public understanding at the time of the enactment of that provision?
From a philosophical perspective, in my view, it is that the public meaning at the time of the enactment, at the time of bicameralism and presentment, that would govern.
Great. And I think that's an important distinction. It's impossible to run the subjective mindset of any individual through bicameralism and presentment. That's the kind of notice we're required to have, we're entitled to have as American citizens before we're subjected to a new provision of federal law. It has to go through that gauntlet, otherwise it's not a duly enacted law. What are the contours of the president's authority to appoint and remove, particularly to remove executive branch officials?
So there are Supreme Court precedents on this issue, Senator, that I would apply faithfully if I'm confirmed. There's also litigation around these issues, so I have to be careful about how much of the details that I get into here. But generally speaking, under the seal of law case, the executive power, and I think the court, I'll paraphrase, but I think the court used the phrase, all of it is committed to the President of the United States. That type of broad commitment of power pursuant to the vesting clause in Article 2 could be read, and it's been said by some that it is the case, vests in the President a power to remove any official in the executive branch. And I think that's tied up in academia, in research and writing around the unitary executive theory. As I said, there's ongoing litigation right now relating to this administration's position regarding these issues, including the head of, for example, the Merit System Protections Board or the National Labor Relations Board.
Yes. Is it proper for a lower court judge, let's say a federal district judge, to flagrantly disregard a direct order from the Supreme Court of the United States?
No.
In circumstances where you're reviewing as a judge on the U.S. Court of Appeals for the Third Circuit, should you be confirmed, there'll be myriad circumstances where you'll be asked to review the disposition by a lower court of a dispositive motion. For example, Rule 12b-6, motion to dismiss, Rule 56, motion for summary judgment. In your view, is one worse than another between a case in which, in a close case, somebody grants a non-meritorious dispositive motion or denies a meritorious dispositive motion? Is either one worse than the other? And if so, why?
So, Senator, that's obviously a philosophical question that I think different people would answer in different ways based on their values and judgment. For me personally, because of my experience with jury trials, I prize the jury system that's enshrined in the Constitution. And so from my standpoint, to the extent, I guess the way I would frame it is, to the extent there's a close question in a 12b6 motion in a civil case, or in a motion to dismiss in a, well, I'll leave it into the civil cases.
If it's summary judgment, you were going down the summary judgment route.
Right. It would seem prudent to me to allow the case to go to a jury, which is really just, to me, a core part of our history and tradition that allows people in our local communities to make decisions and participate in the process.
That's a fair point, and the fact that a judge in that circumstance is in doubt or experiences pause when deciding whether there's a genuine issue of material fact suggests that there is. Thank you, Mr. Chairman.
Senator Whitehouse.
Mr. Chairman, before my time begins, may I